Hello everyone. Today I'm going to start with the subject Indian Contract Act, and my main focus will be on the landmark judgments, the important judgments that you should know if you are in your law school or even if you are preparing for any other examination like CLAT or in fact for judiciary and other legal exams as well. So when I was in my initial years of school, law school, I also felt the need of a source where I could have found the simple explanation of the facts of a case law, and to be honest, it was difficult to read all the whole judgments on my own when I just entered into law school. And for the college exams we do need some source to explain us the judgments in a simple language, especially the facts, because we can easily find the held portion, we can also find the reasoning as well, but relating to the facts sometimes it is confusing, and not many websites on Google or other resources they provide facts for free in a summarized way. So my main focus will be to help you understand the complete chain of circumstances of a case, as well as what was held in that case and the related relevant law provisions also. So I'll be starting with the Indian Contract Act, and in this series we will be completing the important case laws which you can refer to, especially when you are appearing for your college exams and all. So I hope that this is helpful to you all. So let's begin with the subject. Okay, Indian Contract Act 1872. So this is the Act 9 of 1872. It is Act 9 of the year 1872. What does it actually mean? It means कि 1872 ईयर में जितने भी एक्ट्स पास हुए थे उसमें इंडियन कॉन्ट्रैक्ट एक्ट इज़ ऑफ नंबर 9, राइट. मतलब इंडियन कॉन्ट्रैक्ट एक्ट से पहले 8 other acts were passed in the year 1872, and this act is number 9, right. Now the act was enacted on 25th April 1872. Means the enactment date of the act is 25th April in 1872. If you are someone who is not aware of the difference between enacted and enforced, enactment date and enforcement date, then it is very simple. Enacted means, the date of enactment means it is the day on which the bill became an act. Bill became an act. And how does a bill become an act in our Indian structure? Is when the bill gets the assent of the president. So first the bill goes through houses of the parliament, then when it is passed by both the houses it goes to the president for his assent, and the day president gives the assent to the bill, it is converted into the act on that very date. ठीक है. So that is the date of the enactment, that is the day of assent by the president. And now what is the date of enforcement? It is 1st September 1872. The date of enforcement means it is the date on which this act, Indian Contract Act, came into force. That means the day from which it came into force, it started to being applicable on the people of India, citizens of India, right. Now, a question might arise that it is the Act of 1872. Then, how is it applicable even after 1950, when our own constitution was already in force? So, this is by virtue of Article 372. By Article 372, it provides that all the legislations which were in force before 1950, that is before the constitution came into force, they will continue to be applicable. Okay, yeah, so they will continue to be applicable even after 1950 if they are not in violation of the other provisions of the constitution. ठीक है, what I mean to say is that ऑल्दो ये जो हमारा इंडियन कॉन्ट्रैक्ट एक्ट है ये ब्रिटिश टाइम का एक्ट है. 1872 इज़ द टाइम व्हेन वी वर स्टिल अंडर द रूल ऑफ Britishers, right? And it is still, we are still, the government of India, even after we are sovereign, we are still following the 1872 act. ये जो हमको राइट मिला है टू कंटिन्यू दिस एक्ट, इट इज़ बाय वर्च्यू ऑफ आर्टिकल 372. आर्टिकल 372 बोलता है कि जो जितने भी एक्ट थे बिफोर इंडिपेंडेंस, वी कैन कंटिन्यू दैम इफ़ दे आर नॉट इन वायलेशन ऑफ द प्रोविजंस ऑफ द कॉन्स्टिट्यूशन. अगर वो एक्ट हमारे कॉन्स्टिट्यूशन के स्पेशली पार्ट 3 के अगेंस्ट नहीं है तो हम उनको कंटिन्यू कर लेंगे, बिकॉज इट इज़ नॉट पॉसिबल टू ड्राफ्ट and to make all the laws again, right? So we continued the Indian Contract Act 1872 by the virtue of Article 372 of Indian Constitution. Okay, now the question is whether the act is exhaustive or not. Now what is the meaning of the word exhaustive? Exhaustive का मतलब होता है कि ये जो हमारा एक्ट है इंडियन कॉन्ट्रैक्ट एक्ट, क्या ये एक्ट अपने आप में ही पूरा कंप्लीट है? दैट मीन्स कि इफ़ आई हैव अ क्वेश्चन और आई हैव अ राइट और लाइबिलिटी रिगार्डिंग द कंसेप्ट ऑफ कॉन्ट्रैक्ट और रिगार्डिंग द लॉ ऑफ कॉन्ट्रैक्ट, सो विल द एक्ट ऑफ इंडियन कॉन्ट्रैक्ट एक्ट 1872, will it be sufficient and will it be complete in itself, and will it be the only law that I need to refer to, right? Means that is there any other law also that we are required to refer when we are dealing with the law of contract? The answer is yes. Apart from Indian Contract Act, we also have Sales of Goods Act 1930 and Indian Partnership Act 1932, and we even have the Negotiable Instruments Act also. So these are some other acts: NI Act and Sales of Goods Act and Indian Partnership Act. So these are some other acts which are also referred to when we are dealing with law of contract, apart from the Indian Contract Act. Okay, apart from Indian Contract Act, on some points of law we are also required to refer to these 3 acts and even some more. There are some more laws also. So the point is that Indian Contract Act is not exhaustive in itself. ठीक है? And another point that supports the contention that it is not exhaustive is the language of the preamble. So the language of the preamble of the Indian Contract Act, it uses the words define and amend. Define and amend. That means the preamble says that the Indian Contract Act is to define and amend the law of contract. It is not saying that the act is to consolidate the law of contract. Define means that it defines some things, and it amends some things, but it does not consolidate. Consolidate means एक साथ इकट्ठा करके पूरे सब्जेक्ट को एक एक्ट के अंदर कंसोलिडेट कर देना, इकट्ठा कर देना. बट consolidate is not used in the preamble. The words used are define and amend, right? So the act is not exhaustive. So this was the basic introduction of the subject. Now coming to our first landmark judgment on the subject, Indian Contract Act. It is Lalman Shukla versus Gauri Dutt. 1913 का ये केस है एंड इलाहाबाद हाई कोर्ट की ये जजमेंट है. ठीक है. सो टू अंडरस्टैंड दिस केस लॉ, फर्स्टली वी आर required to know the concept of proposal. What is proposal? Only then we can easily understand the case law. So the definition of proposal is given under section 2 clause A of the Indian Contract Act, and it says that when one person signifies to another his willingness to do or to abstain from doing something with a view to obtain the assent of the other. Okay, now what does this mean? See, जो हमारी definition है section 2A के अंदर, उसमें these are the following important elements. As I said, it says, the definition says, when one person signifies to another. That means there has to be two parties. One person, this one person signifies to the another. Now signifies to another, signifies means communicate, right? communicate करता है कोई, मैं आपसे कुछ communicate कर रही हूँ, I am telling you something. And what is that thing? What is the communication? His willingness to do or abstain from doing something. Willingness to do or abstain from doing something. To do is a something positive and to abstain from doing is a negative. So with a view to obtain the assent of the other. Now to understand this definition, let's see an example. This is the person A and this is a person B, right? Now this person A, he says to B, I wish to sell you my car for rupees 1 lakh. Will you buy it? ये जो person A है, ये B को कहता है कि I want to sell you my car for 1 lakh rupees. Are you interested in buying the car? ठीक है. Now what is he doing? He is signifying, he is communicating his willingness to sell his car, right? ये अपनी जो इच्छा है अपनी कार बेचने की वो व्यक्त कर रहा है B को and for a price of 1 lakh rupees. So the person A is making a proposal. This is how he is making a proposal. He is signifying his assent to do or abstain from doing something with a view to obtain the assent of the other. That means कि जब A B को बोल रहा है कि I want to sell you my car, he is telling this because he wants the assent of the other. Otherwise किसी को कोई क्यों बोलेगा? If I say you that I want to sell my car to you, will you buy it? That is because I want you to agree. I want, what do I actually want? That I am hoping that you will agree to buy my car for the quoted price, right? So that is what is meant by the definition. So from this definition, the one important thing that comes out is that the proposal that I intend to make, जो proposal मैं देना चाहती हूँ, it must be in knowledge of other party. That means कि मन ही मन में सोचने से कुछ नहीं होगा. If I want to sell my car, then I have to communicate it, and communication must be in such a way that the other person, that is you, यू हैव द नॉलेज अबाउट द फैक्ट, राइट। जब ए चाहता है टू सेल हिज कार, ही मस्ट कम्युनिकेट इट टू बी एंड बी मस्ट हैव ए नॉलेज कि येस दिस इज़ द ऑफर दैट ए इज़ मेकिंग टू मी एंड नाउ इट इज़ अप टू मी टू एक्सेप्ट इट और रिजेक्ट इट। ओके, सो द नॉलेज ऑफ बी इज़ वेरी इसेंशियल, ठीक है, तभी वो उसको एक्सेप्ट कर सकता है, राइट। अब हम आते हैं लालमन शुक्ला वर्सेस गौरी दत्त के फैक्ट्स पे। आपको अब पता लग गया है कि प्रपोज़ल का मतलब क्या होता है एंड प्रपोज़ल देने के लिए और उसको एक्सेप्ट करने के लिए वन वेरी इंपॉर्टेंट इसेंशियल इज़ कि वो दूसरे बंदे की नॉलेज में हो, तभी वो उसको एक्सेप्ट कर सकता है और तभी वो कॉन्ट्रैक्ट बनेगा, राइट। नाउ व्हाट हैपन्स इन दिस केस, देयर इज़ दिस पर्सन, ही इज़ द डिफेंडेंट, ठीक है, एंड इसका एक नेफ्यू है, दिस इज़ द नेफ्यू ऑफ द डिफेंडेंट। अब ये जो नेफ्यू है, ही वेंट मिसिंग, दिस नेफ्यू गॉट लॉस्ट एंड ही इज़ मिसिंग नाउ, राइट। सो दिस पर्सन, ही asks his servants, these are the servants of this person, and he asks them to go find the nephew। ये इन सब सर्वेंट्स को बोलता है कि जाओ और मेरा नेफ्यू ढूंढ के लाओ, ठीक है। नाउ these servants they go out and they search for the nephew। ये सब चले जाते हैं for in the search of the nephew। After the servants left the house, this person, the defendant, he announces a cash reward। ये एक कैश रिवॉर्ड अनाउंस करता है while the servants are out। जब सर्वेंट्स घर से जा चुके हैं, at that point of time, now he is announcing a cash reward that whosoever will come with my nephew, whosoever will find my missing nephew, I announce to reward him with certain amount of money, right? ठीक है। Now you have to understand that this case is of the year 1913। 1913 का ये केस है। At that point of time, the mobile phones or the communication through WhatsApp and calls, that was not that much prevalent at that point of time, so the servants were very much unaware of this reward when they were out। ठीक है, अब सर्वेंट्स जा चुके हैं घर से, उनके जाने के बाद दिस डिफेंडेंट ही अनाउंस्ड अ कैश रिवॉर्ड, जो भी उसके नेफ्यू को ढूंढ के लाएगा उसको ही विल गिव द कैश रिवॉर्ड, राइट। नाउ व्हाट हैपेंस इज, जो सर्वेंट्स गए थे ढूंढने के लिए, वन ऑफ द सर्वेंट्स ही फाउंड द नेफ्यू एंड ही केम बैक होम विद द नेफ्यू एंड ही found the nephew and he came back home with the nephew, and now when he came back home, now he comes to know about the cash prize, that there was a cash prize for any person who would have brought the nephew back, and now he is claiming that reward। ठीक है, घर आने के बाद उस सर्वेंट को पता लगता है कि एक कैश रिवॉर्ड अनाउंस्ड था उस पर्सन के लिए जो भी नेफ्यू को ढूंढ के वापस लाएगा, और अब वो क्लेम करता है कि क्योंकि मैं नेफ्यू को ढूंढ के लाया हूँ वापस, दैन यू शुड गिव मी द कैश रिवॉर्ड। नाउ द क्वेश्चन अराइजेज दैट कैन दिस क्लेम फॉर द रिवॉर्ड बी इन्फोर्स्ड अगेंस्ट द डिफेंडेंट। दैट मीन्स कि क्या उसको क्लेम मिलना चाहिए। वॉज देयर एनी प्रपोजल, वॉज देयर एनी कॉन्ट्रैक्ट, इज़ दैट कॉन्ट्रैक्ट इन्फोर्सिबल और नॉट, दिस इज़ द क्वेश्चन। Now you think about it and try to think whether there was any proposal which could have turned into a contract and could have bound the defendant। See, as we have already read कि एक valid proposal के लिए it must be in the knowledge of the person to whom it is made। ठीक है, अगर वो उसकी नॉलेज में नहीं था, ही कैन नॉट एक्सेप्ट द प्रपोजल, राइट। तो यहाँ पे क्या हुआ है, सर्वेंट्स की नॉलेज में ये जो ऑफ़र था ये था ही नहीं. They did not knew about the offer. When they went to search for the nephew, they were unaware of any such offer. They went to search for the nephew only by virtue of their duty. ठीक है, तो उनको जब ये ऑफ़र के बारे में पता ही नहीं था, they could not have accepted it. And because they could not have accepted it, there was no agreement or contract that could have come into existence. So the same thing was held in the case. No knowledge of proposal was there, so there can be no acceptance and no contract was made. ठीक है, because उनको knowledge ही नहीं थी, so proposal was not complete and no valid acceptance could have been made, and thereby the servants were not they could not claim the reward. Okay, so that is it for today, guys. If I could have helped you understand this case law, then I'll be happy to know about it. You can comment your views, and thank you for today. Thank you and have a nice day. Bye bye.